we'll just get started. Thank you for coming so numerously. Very pleased to see so many people. This is the panel, I think it might be the fifth panel that's talking about the Digital Omnibus. Don't worry, we're also really fed up by it. So we'll also have our little moment of stupefied rage. Maybe that's how I would describe my initial reaction to the proposal. So we'll just go with that. I'm Felix Pieker. I'm moderating today. I am working at the Data Protection Authority of Schleswig-Holstein in the research department. So I'm not doing your cases if you submitted any complaints. But the commission is right here. You can ask her later. I'm also a researcher at the Leibniz Institute for Information Infrastructure. So double affiliation as of recently. And I have a very good panel selection, I must say. If I were to tout my own horn, it would be for the selection of the speakers. Right next to me, we have Maria Magiaska from Maastricht University. We have Ichazo Dominguez from EDRI. And we have Midas Nouwens from the Autoriteit Persoonsgegevens, the AP, the Dutch data protection regulator. You'll be hearing more from them, and mostly from them. But just to set the scene a little bit, I am gonna set the scene a little bit. I'm on the record with Katie Nolan of saying that suddenly the EU has been grappled with AI FOMO. We can very much see the moment in time of the release of the Draghi report when it started to become very apparent that the Commission is hitting the brakes on all that it had acquired more or less previously for data law, because now we need innovation, and we'll talk about this quite a bit, but according to the Commission, the only way to innovate can apparently be AI. We need to compete, and we need to compete with China and the US on AI. There's no other way. There's no other things that we could be competing about or with. And we have to do it on their terms. We can't really do this whole European values thing that we've been touting. It's kind of been dubious. I'm not a big fan of touting European values too much. And maybe we'll get into that if we run out of questions otherwise. But we're not doing that anymore. We're really doing it on their terms. And this is an ideology, of course, and it's not new. We've been seeing this come back and forth for a couple of circles at this point. It's about the supposed efficiency. It's about deregulation or further empowering, well, companies. And at the same time, we're seeing how AI and algorithmic decision-making are wreaking havoc on people, especially marginalized groups. We've seen it affect the lives of queer people, migrants especially, of course, racialized people. They're all becoming the testing grounds for this new, better, at best technology. And that's not just happening in the US. We've had cases repeatedly in the Netherlands. But not to stop there, the Danish were like, well, they've had issues with this. Well, we can replicate this very fast. And they did in their own social services. And it didn't go well. The German police also really needs Palantir now. And don't worry, they're not all like that. Some of them want a German Palantir because digital sovereignty. So that's progressive. Meanwhile, I'm just sitting here writing my research, and I'm finding that none of the issues that we're facing right now with this technology are new. There's been articles out, there's been people voicing their concerns, affected communities. We've heard from some sex workers here who have been sounding the alarms for a long time. We've had researchers research this topic, issues of misgendering people with AI technologies. That's all been out since 2016. The receipts are all there because they're published. This is the fun bit about academia. And we have civil society organizations who've been doing a lot of advocating, not least about the Digital Omnibus, of course. And on the administrative level, we're seeing how the simplification and efficiency is also a great way to get rid of checks and balances, because we need to move fast now, right? In the administration as well, we need to make things more simple, more lean. Sometimes things are maybe supposed to be a little more complicated. And somebody said to me that, arguing for complication instead of simplification is kind of arguing against protecting children. And I see the allure of the argument, but I also see the very deeply democratically necessity of having a few complications in some procedures and not having somebody just rule through what they want to achieve. And I think we've seen, if you were at one of the earlier panels today in the Grand Hall, I think we've seen that the Commission has been surprised by any and all criticism. They have not looked keenly on it. They have not looked really introspectively at foundational critiques they have been receiving. They have been very contemptuous of researchers today. And this is the general scene that I think we're facing. And this is kind of the level that we want to be talking about today. So I'll just leave it for my esteemed panelists to do a little opening, and then we'll move on to a general conversation, and then we'll get all of your questions in, of course. Maria, do you want to start?
Yeah, thanks so much. It's always a pleasure to be here, and thanks so much, Felix, for such a nice opening and setting a scene for a discussion. So I really like how you suggested to frame this panel about the rhetoric. So instead of maybe focusing on the specific provisions of the omnibus, we can discuss more about what's going on in general in Europe at the moment and how to address what's happening and what can we do as academics, authorities, activists about it. Because I feel that the general sentiment is that we are not happy, and we can see it also. There's this. There were research done, and the Eurobarometers also show that Europeans, they in general actually want harder stance against big tech companies rather than this simplification agenda and leaving them more way into our lives. And so we hear actually, at this conference, we hear a lot of these big words that I feel we can maybe use this panel to reflect more about what we actually mean by them. And one, obviously, we have simplification and deregulation. That's obviously one thing of it. Then you have competitiveness, innovation, and digital sovereignty. So like these three big words that I am just not sure whether we have the same idea on what can they entail. So I feel it's clear like why the Commission, not only the Commission, is this the agreement after the Draghi report that the EU needs to be competitive to fight and to win this war with the US and China and like the or rivalry rather than a war, and I think as a fact it's true that we have American companies on the one side that indeed are processing the vast number of data, and most data that are processed, and we are Europeans are mostly giving this data rather than creating them, these devices that would further process them. That's true. But then what is this competitiveness? Why ultimately we do need it? Obviously it's for this digital sovereignty. But then I feel, and this is maybe when I'm adult with this logic that Commission proposes, is that the only solution towards this competitiveness and to achieving it, and to achieving by that digital sovereignty, is by pursuing simplification. And for me, what is proposed in the omnibus, the way it is proposed, only some parts of it are qualifying as simplification. Those that going as far as redefining the concept of personal data, the boundaries of legitimate interest and so on, for me, this is deregulation or completely opening the GDPR. So I think it definitely goes beyond the scope. But still, this is kind of seen as the only solution. We will remove these rules, the EU companies will suddenly innovate, and this is how they will win the big tech companies. And so. But is this the only way? I don't think so, because it's a bit removing what the Europe was actually, we have this old, like the theory, digital empires, not perfect, but actually in this simplification, that was kind of the European force, that we have the rules, and this is kind of how the weapon that we use, right? And it's like removing the single thing that was distinguishing us from the others. No? So I'm just I really look forward to the discussion, because it's not like we will have an answer to this, but I just want to talk about it.
Perfect, thank you. Jassa, want to add to that?
Thanks so much. I'm really happy to be here, and I'm really happy to be surrounded by amazing people, also the people in the room. So I represent EDRI, for those of you who don't know, shame on you, but we are the largest European network in Europe of digital rights organizations, experts and individuals. Some of our proud members are in the room. And the work that I do when I work on GDPR, e-privacy, commercial surveillance, and consumer, I do that thanks to them. So it's not only me. So, but something that we have been seeing at EDRI and across civil society and trade unions as a whole is this problem with the broader deregulation agenda, right? The Digital Omnibus was the 7th omnibus. 10 of them are already on the table, and we can see some common characteristics, right? When it comes to the process, we already see many problems. You spoke about the fast, how it has to be fast, and actually I was working also on the AI Omnibus, and something that was I wanted, every time I want to speak with PEM reps or people in the parliament, they are like, oh, this article. I'm like, no, we didn't have time to look at this and this. And I'm like, okay, but you are changing these articles and these can have an impact on fundamental rights. So and it's like, no, we don't have the time. The message from the capitals and from the commission is that this has to go fast. So that was already quite okay. Afterwards, you have this idea of a package deal, so and which is the omnibus in a nutshell, right? You put different amendments to different laws, and then you throw it to the co-legislators, and then they feel forced to be bound by this idea that we have in Brussels that at least some of it has to pass, right? And maybe some of it is, as you said, what we see at genuine simplification, which is very little when it comes to the Digital Omnibus, if I may add, and only one really good thing, which is privacy signals, we can speak afterwards. But the rest, is going to be about negotiation. And we don't want to leave everything up to negotiations, right? This is in a very fast process. The lack of impact assessment, we have discussed that, and the Commission gets annoyed every time we mention that, but this is the truth. You're attempting to change fundamental rights law, and actually when we speak about GDPR, even more so than the AI Act, we're speaking about a law that is not just about the fundamental right to data protection, the charter right. It has to do with the rest of fundamental rights all throughout the charter. So again, you need an impact assessment and a fundamental rights and justice impact assessment, because every time I say impact assessment, it's true, what's going to be the impact on companies? And yes, but of course, what's going to be the impact on fundamental rights? And also, I have to say, because something that we have been discussing is that, okay, but then because there's going to be already a process, which is the digital fitness check, through which all of the digital rulebook or all of the laws that have a digital component, good luck with that, might be subject to this fitness check. But also, I always say, but there should also be red lines, right? Because even with an impact assessment, even going through the whole legislative proposal, we shouldn't accept that this idea that fundamental rights law should be reopened every now and then just because companies are calling for that. And I will say, there's a factor in which, there's companies, governments, big tech companies, but also companies in Europe. And I'll explain why afterwards. And then we have the problem of less democratic oversight. First, because of how civil society is perceived and how the power of big tech, but also other industry has been growing in Europe. And now every time you go to the parliament, they have already had 75 meetings with industry, and they're like, oh, we're also going to meet with EDRI. And it's like, okay, thanks, I'm very thankful, but maybe we should meet with more civil society. But also civil society is drained because all of the burden about, going against that is put on us. Not all of it, DPA's regulators have been amazing, council, most of the member states have been amazing, and parliament, I hope that they will be amazing. But, civil society, we are already working on lots of it, and we are under attack as a whole across the European Union, right? And then we have the problem with content, right? We're speaking about fundamental rights. We're speaking about a shift towards more self-regulation. I thought that the digital rulebook was adopted because we didn't trust self-regulation, and self-regulation has never worked. Why are we giving these companies more power? Why are we giving companies the power to say, now the GDPR doesn't apply because I applied a pet, this pet that has become like unicorns in Brussels. And what we see is this race to the bottom. This is why I was mentioning EU companies and not just foreign companies, because instead of focusing on what we should be focusing on, we've been calling on the Commission to focus on that for years, on enforcement, in order to have a level playing field, in order for companies, European companies, to feel that big tech, especially American companies, but if you want Chinese companies, and I think we fall into very racist, black holes every time we do this distinction, because there's really good American companies and there might be really good Chinese companies. So they feel that because of how GDPR enforcement works, and even how e-privacy enforcement works, there's some companies that are left of the hook, right? When the one-stop shop mechanism is not working, the Commission tried to make it better with GDPR procedure. They didn't manage to do that. But so now European companies are convinced that they have the only pathway that they have towards achieving more competitiveness, as you mentioned, and what kind of competitiveness is this race to the bottom, right? And actually, you mentioned that it's not just the EU Palantir. Now I hear European companies, I want to compete with Google, and it's like, no, you don't have to compete with Google. Google has to be broken out. Google has to be held accountable, and you need to abide by the rules and create trust amongst the people and respect the rights. And I'll finish in 1 minute, sorry. So I was already saying, instead of focusing on what matters, which is enforcement, protecting people, and looking at the evidence, I think this is something that we really, really should be worried about, right? We've been speaking about the post-truth era, the fake news era, and we make fun of Donald Trump every time he says fake news. But every time I have to read the Draghi report, I have to listen to the Commission's arguments. This is post-truth. Most of it is things that wouldn't hold in court. Why would it hold? Every time, and because we don't have an impact assessment, the Commission just said, we're saving 5 billions with all of this. And it's like, okay, 5 billion? Where does it come from? We have done extensive research. We have done extensive consultations. Okay, I've been part of these consultations. This is not enough. If you have the evidence, publish that. Draghi, the paragraph he has on the GDPR, this footnote with a research by academics, by American academics, all my respect to academics, but you need to have evidence on why the GDPR is not working and why the GDPR has become the biggest obstacle for European companies to be competitive, right? I'll leave it at that because we have so much to discuss. Sorry, that was a little bit long.
Thank you. All right, Milos, what's the regulator's perspective on this?
Yes. Since we're basically just doing a small trauma dumping session. So the official position of the DPA is that we are in favor of simplification as long as they protect fundamental rights, that we would be okay with this hypothetically. I think if you read the EDPB opinion that we've put out, if you read between the lines or just the actual lines, we are quite critical of the work that has been done. I think a lot of the proposals that have been made, as you said, there's no impact assessment, so we're not quite sure what the evidence for some of these suggestions are. And then also, even if you are in favor of changing the particular articles that have been touched, there's also just a lot of inconsistencies. Like in some of the articles, they're referring to, here's for AI development and deployment, and then in the recitals, different words are being used, so that it just introduces a lot of confusion about what actually is being talked about. So the actual quality of the proposals, I think we've struggled with. To put on top of that, because of the fast pace that this change had to happen. This happened the fall last year. The Dutch DPA is one of the most well-funded and biggest DPAs in Europe. So in general, we are quite proud of all the work that we do and the colleagues that we have. They're excellent, right? But we also have limited capacity. So in 3 months, have to go through all of these different articles and do really intense legal analysis of what the possible complications of this are is really, really difficult. To then do that also at an EDPB level, it's been a really, really squeezed process that not only was that difficult to do in itself, it took away a lot of the resources from the other work that we've been doing. So just to name an example, we've been at an EDPB level, also at DPA level, we've tried to figure out guidance on generative AI and whether or not this can be developed and deployed lawfully, right? Now there's a new legitimate interest legal basis that's being introduced, even though through our own analyses, which we haven't been able to complete, but should be published either next week or the week after that, we do come to the same conclusion that under the current wording of the GDPR, this would already be possible. Mm-hmm. So why are we introducing this new thing? And you're taking away the resources from us as a DPA to figure that out by shoehorning in this other very specific, technology-specific lawful basis. So we've had a bit of a struggle with that. Not only us, but also the Dutch Parliament has responded. It's really hard to assess the quality of this just because there is no impact assessment. So the lack of an evidence base makes it really difficult to have a conversation about it. And then you do end up in basically just a rhetoric discussion, right? Of yes, we want simplification, or yes, we need innovation or competition. But even with the, if you really believe in the mission, it's difficult to really know whether or not you can trust any of the statements that are being made, such as whether or not we're saving 5 billion. Or things like that. So we're looking forward to see what the latest amendments are going to be.
Right. Very much, I suppose. And I mean, you've mentioned the rushness of it all and the sudden activity. And I think thinking back a couple of years, civil society and the authorities as well were very reluctant to open this back up. Not because we didn't have grievances with it, not because we didn't see inefficiencies and redundancies and also issues in enforcement itself and in enforcing this risk-based approach that is very self-regulatory, very self-assessment-y, and creates a lot of issues and creates a lot of legal uncertainty, to then have this rushed package that adds to it ultimately. And of course, the Commission this morning was very quick to point to DPAs and them not doing the enforcement, which, I mean, there's been issues. Don't want to say there hasn't, and there's ongoing structural issues as well. And at the same time, of course, it's easy for the legislator to point at the enforcers. However, we can only enforce the law that we have, and we can only litigate the laws that we have. And I think this would have been a great opportunity to look into some of the structural issues that we're seeing. And maybe exactly because you're already starting up, which is great. And maybe you can talk about some of the changes you would have actually liked to see. Maybe some things where you just maybe pick one, your favorite change you would have liked to see in EU data law. So
I can start.
Yeah,
No,
sure.
you
Yeah.
want that? No, okay. No, because I like how this discussion almost immediately gravitated towards enforcement, and
I'm biased, sorry.
I think this is really the core. We can put anything in the omnibus, but if it is not enforced, then like what's the trouble even? And I was actually thinking, because we have this experience, example from the Dutch DPA, and I was actually thinking of the Dutch DPA itself, because and it's not an attack.
Good
I'm
thoughts,
sorry,
okay,
it's not an attack, but it's true. I think, isn't it the Dutch DPA who actually has in its report now, is the program for the next years, that they will minimize and impose the administrative fines only in circumstances when it is necessary, following it up the control that was done from the state. So it's really a discussion about the independence of the DPAs and the logic that is behind even this limited resources and where is it going. If the DPAs themselves, it's not only the Dutch one, I think a lot of them are, they need to streamline the complaints, they need to streamline the actions. But what we see in this enforcement action as the GDPR is now is that this data subject-based, rights-based complaints are treated less meaningful and less worthy of proper enforcement actions. Again, like DPAs, they need to make these decisions because they don't have much resources. But it's also fair, and in this new procedure, we will have these early resolutions that are applicable only to data subject rights complaints. So what it is in practice, because of course, if you talk, and I don't know if it's your experience too, that I understand most of the DPAs, the complaints that, like most of them would be somehow like neighbor complaining for another neighbor that they are using the camera, and like the classic one, but they're also the very classic violation in the end. Very systemic problem. And what the DPA would do, instead of triggering action, they would send a letter to a neighbor rather than doing the full action. So there's something wrong here, even in how we understand it, perhaps this high level. So if there's something I want to see, if I could design the GDPR, would be this dividing it into more levels of the process, anything that would actually address this issue of different types of processing that are there, different volumes of processing. And also one thing that critically I think is necessary is the way of clear rules of these documents about interacting between each other. So it's the I'm talking also about enforcement actions between DPAs and all the other authorities, but in general also for the controllers. I think this was the clear message from the controllers, if anything, that of course they have NIS here, they have the GDPR, DSA, DMA, like clear rules on how they are interoperable. It's very necessary, but that's...
Yeah.
First, just to clarify, of course, if I had a wish list and I knew that this could happen, I might have some ideas and I might just mention some of them. But the thing for now is that for me, I really struggle with that because we have such an insufficient enforcement, right? The one-stop shop mechanism is not working the way it should. But that doesn't mean that we should change enforcement, because what I see, and that might be a conspiracy theory, but amongst friends, is that all of the Commission blaming the DPAs. And let's not forget that the Commission is ultimately responsible for the enforcement of GDPR, right, when it comes to the resources. For me, that's very funny. Yes. But also the resources of many DPAs. You mentioned that the Dutch DPA is very well resourced, but we have DPAs that say, we are drowning, right? It's not just because they're drowning because now they have to speak to their capitals to the EDPB about their opinion on the Digital Omnibus. Is that, and I'm not saying that people go to the DPA too much, which is what some DPAs is that they should have more resources, not just in terms of money, but also in terms of expertise. Because what we hear from many of our members is that the best people, the people who are the best prepared, they go to the private sector because working for a DPA, unless you are very passionate, it doesn't make sense. So I think we have to ask this question. This question should be asked if enforcement was much better. Not ideal. Nothing is going to be perfect, but ideal. And actually, when it comes to enforcement, it's not even about changing the GDPR. I think when you mentioned this cooperation between authorities, I'm one of the people who believe there should be a duty to cooperate between regulators. Again, more resources. I'm never going to deny that. Even a duty to exchange information, also if it has to be redacted. The DMA already hints at that. And what we see from some regulators is that they know that it will be better to have a joint investigation when it comes to DSA and GDPR and things like that. But there's this chilling effect, right? Because there's not a legal basis for them to cooperate, except for the courts coming in and saying competition and data protection authorities have to cooperate. They don't do that. Also because they're overwhelmed, so they already have mandatory things to do. So yeah, I think enforcement, I will try to address that, and again, the Commission should have been working on that for years instead of reopening the GDPR, reopening e-privacy, or whatever that might come next, or thinking about centralizing enforcement, because this is a rumor in Brussels, and rumors in Brussels tend to be true, right? And the fact that the Commission says, oh, maybe GDPR enforcement needs to look more like DSA enforcement, which maybe, okay, I don't have an opinion on that, but you're also reopening GDPR. And why I say I'm a little bit hesitant, because what we've seen in the other omnibus, what I've seen in the AI omnibus is not that the process is completely full of issues and that have to worry us all, but also this is how negotiations work. It's any crazy person, and there's lots of crazy persons involved in this process, I'm really sorry, can come up late at night and say, oh, let's drop an amendment, and because the rest of the people, they don't know how to react. Some people are not well prepared because this is a very technical affair, and that might go about and might, change the GDPR in essence. And again, we're just speaking about a fundamental rights law, so I'm really afraid of even proposing, because this is what sometimes we're being told. Okay, so what would you change about GDPR if you could in this digital omnibus? And I'm like, no, don't touch it. Don't touch it, not because there's not things that that could be improved. It's just because the current political arena is not in favor of fundamental rights, right? And it's about all of the marginalized communities you have spoken about, but it's about the whole of the people. They don't give a damn about the people, and even about the children, which they pretend to protect, to defend. But we see this huge cognitive dissonance, right? You want to protect children. Everybody's saying that, and anybody in Brussels that says maybe it's like, oh, you don't like children, you hate children, because at EDRI we've been told you hate children so many times, but at the same time you're deregulating the rights. It's not that GDPR wasn't protecting children in a very specific manner. It's not that as if the rest of the digital rulebook also can contribute to protecting children. But no, we're protecting children, just age-gating them, just or banning them from social media. But the rest is you fend off by yourselves, which is most of what the Digital Omnibus is about. When it comes to, for example, access requests, when it comes to other provisions, right? You see this idea of you are abusive, you are already assumed that this is abusive, that people hate. I've been told that by a DPA, I won't mention what, in a panel. He was like, but people hate companies, so they take vengeance against companies with the DPAs. Like, do you think people are that motivated? This is very anecdotal, and with anecdotal things, this is how we're getting to the omnibus. All of it is fully anecdotal, but if I had to change something, I'll stop at that. That would be Article 22 if we were in a different political climate. Yeah. we had lots of technical people caring about fundamental rights in the Parliament, in the Council, and in the Commission. I think this is one of the most powerful articles of GDPR.
And we could even look into the Platform Work Directive, because there's some interesting legislation on that whole topic, and that kind of gets chopped all the time. But yeah, I mean, also picking up on what you were saying, the Commission centralizing enforcement. Well, I mean, the rumors in Brussels and the reports are that the Commission isn't really so much enforcing the DSA because it wants to appease the Trump administration.
But also,
so we don't know how that would play out politically, because they are a political organization. Let's not forget.
It wouldn't be the Commission. I think all of us agree. I'm about to do a poll that if the GDPR is enforced, it wouldn't be the Commission.
Yes,
sorry, but then I will address it. But do you see how the elections of the DPS are going on? So I don't
elections?
think
What do
there
you
is
call
a risk with
elections?
centralization that
Elections?
anything can get political.
No, I'm not against. I'm just saying that because of the charter, the Commission cannot be the enforcer. I'm not saying that the EDPS should. I think after 1 year and a half, we all realize that there's a big problem there, but there's a big problem with the institution, but also with the Council and the Parliament, who don't want to sit and decide on a process, and they don't care about the impact that this is having on fundamental rights.
If I can add something to that, maybe procedurally, just to close it, like the potential centralization, whatever there is, it already with the one-stop shop, this is one of the problems that we have, is that it really removes individual from this procedure. So on the one hand, you have to be a data subject individually affected by the processing to file a complaint. But then the further it goes in the procedure, the less influence you have on the complaint handling mechanism. You will have some procedural rights with your DPA, to the extent it's not an LSA, because there will be also this difference. And then the moment it goes to the DPB, you just lose your procedural right completely, because they are not treated as concerned. And then in the court, we just had the judgment. WhatsApp can go and appeal for the annulment of the DPB decision, but I don't see a possibility as the way it is designed now for the complainants to do so. So really, and centralization actually will open even further, like solidify it even further, I think.
Okay, and maybe we'll move on to Midas. And if you want to add to anything that was said, or add your personal little wish.
So the question was, is there anything I'd like to change to improve enforcement? Correct?
Or generally the GDPR, if you'd like.
I think one way to achieve both simplification, more legal clarity, and hopefully also better fundamental rights is to have more forbidden practices in the GDPR. So as a data protection authority, what we spend a lot of time on is doing all the investigations, like, is this personal data? Where exactly is the data controller? Does this meet the standards of informed consent? And, there's a lot of kind of procedural steps that you have to go through. If there are more things that are just banned, that would make enforcement a lot easier, and I also think a lot faster. Yeah. So that's another way to go down simplification, legal clarity. So I think this idea of like a white list and a black list that has been floated around a little bit could be going in that direction, which I wouldn't be completely opposed to.
And we've seen, and like Michael Veal has been pointing that out since the draft was out, we have a little bit of that in the Platform Work Directive, where suddenly this worked, and I wonder whether enforcement isn't going to be a little easier for that one. So yeah, there's a couple of things that we could dream of, and the political moment is as we know. And I'm wondering, kind of, because on my worst days, when I'm at home working and looking at all of this and looking at the Digital Omnibus, I'm wondering whether is it really going to affect the current state of data protection compliance that we have, and with all the issues around alleged legal certainty. Does the Digital Omnibus still even make a difference? Is it going to get so much worse? And do you have any thoughts on that?
So I think the changes that are currently proposed in the omnibus. I think at this point you've been hearing about this for so many days, if you haven't already, for the news for the past months. But for those perhaps who don't quite know, so one of them, is the changing the definition of personal data. Another one is creating more lawful basis for AI development, things like this. And I think the changes that are proposed are around topics that, at least from a DPA point of view, we already see a lot of confusion or non-compliance around those. So this idea of like, oh, is this personal data? Yes or no? Well, it depends on your relative test and what else you have access to. These are already, honestly, these are the challenges that we just face all the time already when we talk to any particular companies. Like, do you know if you have personal data? Yes or no? And then their definition of personal data is do I have somebody's name, social security number, or an address, right? So just by enlarging that definition, I think in a way it's just covering the practices that are already happening. The same thing with this lawful basis around AI development. I think that's already possible under GDPR at the moment. I don't know if that's going to do anything specifically. So I think what it does is actually create a little bit more work for the DPA, especially when it's adding more gray zones. So again, around this definition of the definition of personal data, it now creates a lot more work for the DPA to try and figure out whether or not the GDPR applies in that particular situation. Because now we would have to go in and assess, does this organization have the reasonable means to do that identification? Right. So actually, it makes our work harder. So I think that would make enforcement difficult to do as well. Because that really is the first, I mean, it's a bit boring, right? But it's the first test that we always have to do. Like, are we as a DPA even competent to do anything here? Is there personal data? We spend a lot of time doing that. So making that first step harder, more vague, would make our life more difficult.
And yeah, I mean, agree. On one side, it's boring. And on the other side, of course, there's companies that are always putting a lot of resources into arguing. You know, how long have we been arguing about LLMs and whether they're using personal data? And we had the same thing already with big tech. We had the same thing with social networks. So it's kind of a recurring theme. Just throw everything at it, create legal uncertainty, perhaps. That makes it easier. Ichaso, do you want to?
Yeah, but I really want to emphasize this legal certainty or legal uncertainty point of view from the point of view of the regulator, but also from the point of view of companies who cannot navigate that. I think at some point we've heard that from some companies, even if sometimes every time I tell that, the commission is like, no, all companies are delighted with the Digital Omnibus. Okay. Evidence? No, not to be found. Pinky swear. But we hear from some companies that, you know, even if you have a DPO, because of how badly written the text is, right? It's going to be really difficult to assess that, and they know that it cannot go to the DPA because most DPAs are overwhelmed. So if you have a question about the application of GDPR, it's going to be difficult for them. Again, I don't want to blame DPAs. I think this is not the DPA's problem. This is the Commission's problem.
Sometimes it might be.
Okay, if I may.
Just to put
maybe the Irish. I know. Okay, some of them. So the legal certainty is one part. So our companies are small and medium companies, because all of it is made in the name of the European companies, but especially small and medium companies. Now we're speaking about small, medium caps, and the new definition of SMCs is up to 1,500 employees. So these are most of the European companies, I have to say. But most of them, they don't need any of these changes, and actually they are afraid of how this is going to go about. You know, they have 3 years of negotiations, maybe because of how slow the Parliament wants to take it, thank God. Strategic litigation is going to happen. DPA is not understanding how this is going to be enforced. This is a number of years, and companies need legal certainty, and it's only the most powerful companies, either foreign or not, that are able to navigate, which is what we say, you know, these are the ones that are going to take advantage of it, not the small companies. And again, I'm not going to mention the small hairdresser, right? But the companies that don't want to use AI or are actually forced to use AI, which is a problem that we're seeing. You need to use AI because this is the only way to survive. And it's like, but the service that I provide doesn't have anything to do with AI, right? But something that I wanted to say is that I really see more danger, right? Because precisely of how enforcement is not going the way it should, I really see a danger in many companies just self-asserting the GDPR doesn't apply, and all of these, you know, conveying throughout the supply chain. And we're speaking about very, very dangerous contexts, such as AdTech, you know, and AdTech is actually, you know, really, really happy about what's happening, right? But we also, something that we promised we were going to be too technical, but also we see companies that really have asked for years to have more access to devices, which is what privacy is about. You know, the Internet of Things is not just about phones and computers, but it's also about your smartphone, your smart oven, your smart car, your smart whatever. And nowadays the principle is that they should only access to that if there's consent, and if not, they cannot, right? And now one of the Commission's proposals is putting that under GDPR. So companies are now arguing that they could use other legal bases, right? Because GDPR is more of a balancing exercise than e-privacy. Privacy is more, and it's a different fundamental right, and it's a different point when it comes to the collection of data, right? It's more upstream. And I really see those companies also, I think, how many of you want to be tracked? Okay, nobody. But I think we are not aware of the level of tracking that we are subject to every day, every second, and this is only going to get worse because now I see companies saying, and again, it's not just big tech; it's like companies that only work with ovens, Volkswagen, and all of those, and EU companies that say, no, we should be able to access devices, because we need the data, and it's like, okay, but why don't you ask for consent if people want to be tracked? That should be okay. It's like, no, because people need consent only where it matters. And you're going to decide only where consent matters? Of course, and it doesn't go that way. And it's not, we've had this conversation about what legal basis is more important than others, right? And it's not that consent should be absolute. But also, maybe from an enforcement point of view, you have something to say. How is legitimate interest being enforced these days? Because what I hear is that companies actually they should theoretically go through the 3-step test, which includes not just the balancing exercise but also necessity, proportionality, legality, right? And most of it is illegal if you ask me when it comes to LLMs. They don't do that, and when the DPA, if at all, comes to them, it's like, oh, give me 5 days. They just choose to go legitimate interest instead of taking into account all of the steps, right? And the rights of the subject, which are almost impossible to exercise when it comes to processing like LLMs, or even when it comes to access to device. All of this data, according to the new Omnibus, can be subsequent processing without any kind of asking for a new legal basis. So again, this is not just about AI. Even if AI is very important, it's also about your most intimate information at home, which is this Internet of Things, which, if you ask me, it shouldn't exist. But if it exists, it should be with informed consent and with no alternative legal basis.
Yeah, Maria, do you want to?
Yeah, I can just add, maybe after listening to you as well, what bothers me a bit in this discussion around the negotiation. As much I agree that we need some simplification, as I said, and there are these elements that absolutely are there to be like patched a bit, but instead I feel it's really like this discussion, we need AI, and suddenly everyone turned to AI, and we had this discussion 10 years ago, we were just discussing with the big data and so on. Or now, with the AI Omnibus, there's this new provision against the nudified picture, which is good that it's there, but what I'm saying, it's really becomes very casuistic, which was completely against the objective of the GDPR. It was supposed to be tech neutral and ready to embrace different technologies, and suddenly we have personal data proposal that relies on this one judgment. We have this one proposal, the legitimate interest provision that explicitly mentions just AI.
Special categories data.
Yeah, like this. So it's really all this research with commercial objective, which is in mind of the Commission, is this medical research. But then I think when I saw this provision, I was immediately thinking when the Facebook used to do this A/B test. No, this is also research, and they were saying it's a research. So it's this is something that kind of makes me, and I know also people that it's not the only omnibus that's there. We have the omnibuses. There's a couple of them in different areas. And when I was talking to people from the other fields, from the environmental law and from the energy, like they have the same observation that is very casuistic in the end. And I don't think if in the long run it will create more certainty, actually, because we may end up with what we had before, that we had, we have e-privacy that was created so many years ago, and currently we are just trying to make it relevant. So I just don't think this approach towards regulation is workable in the end, when it's just clearly we need AI now. But what if in 10 years, I don't know, next year we will be talking about NERA data or something, and will we be changing it again?
Blockchain?
Yeah,
no, I think I hope that's over actually.
So.
But yeah, and this is I think the analysis is all here, and for us it's relatively visible, whereas others choose to ignore it. But I do think because what I like to think about as well is, so what can we actually do in our respective positions to change this? How can we get ahead? Because as Abeba Berhane and like Timnit Gebru have also been saying, we need to kind of get ahead, right? We can't always keep running around the tech or running behind the tech and fixing it. And I don't think it's a good idea always to only be running around the commission, running behind them, telling them, well, this isn't gonna go very well. How do you think in your work, and maybe have already experience in, how do we change the narrative? How do we get on top of things?
I'm not sure if the DPA has a role here. As much as I think perhaps I would like it to, I think the struggle that we sometimes have as a data protection authority is that you also need to work on maintaining your legitimacy and your authority. And that does sometimes also mean that you have to be very aware of this narrative and the discourse around it. So obviously, we are there to enforce the law, to make sure that companies are compliant, right? And we don't have any choices within that. It's just things come to us, we see violations, we have to enforce. But we also see that part of compliance is the perception that our population has of our legitimacy as an authority. And one of the balances that we've had to grapple with is that if we come out of the gate too strong or too strict, or at least are perceived to be very, very strict, then the critique that gets lobbed at us is that, but you don't take into account the interest of the small companies or of these particular situations. And so actually it undermines the authority that you have, and it undermines also the legitimacy of the law to some extent, where then companies are like, but it's just the Autoriteit Persoonsgegevens being, anti-innovation, anti-whatever. So we do now, as an official communication policy, also have to often mention, okay, well, these are the things that you can do, not just the things that you can't do. These are the opportunities that are perhaps here, not just the risks that are there. So as an authority, you have to kind of balance that communication strategy and those narratives. And so I think because of that, it's a little bit difficult for us to be like, and this is how we want to change the narrative in society to be more in one particular direction, because it might actually undermine us in a way.
It's
so
interesting because, of course,
it.
that discourse also exists in human rights,
Sure.
right? And it's always about, okay, you got to tread lightly, because otherwise they're just going to abolish it in the whole thing. But I think it's a dangerous course to set, because when we're talking then about the legitimacy, and if there's actors involved in questioning that legitimacy, right? And I think that might not
Omnibus proposal is one of the actors that's questioning that legitimacy.
Yeah.
I don't know if the Omnibus is acting so much as the legislator.
Sure,
or
but
the
like
institutions pushing it.
The current debate about
Yes.
how the GDPR is such a blocker for innovation and other things is undermining the legitimacy of the data protection authorities.
Exactly. Yes.
Which is a difficult balance again for us, because like you want to be constructive, or you have the role to be constructive, so you have to be part of these EDPB processes, and you want to be like, okay, what is possible here? But if you write things in there like, this is now the lawful basis that you have to do all of this stuff under, it undermines anything else that we might say. So I find it quite
Can
tricky.
I still ask you some question, actually? Because I was thinking, I know that is it really that the DPAs don't have any role in it? Because I got the impression that actually part of the enforcement problems or approaches, well, I mean, it's like there are clearly some DPAs who made specific choices of how they balance, I don't want to call them out here, but definitely there are DPAs that are more open to experiment with enforcement measures, the others that are more open for this more reconciliatory approaches. So I feel there's still the whole spectrum for the DPAs on how they can
ex officio investigations.
I mean, we have also just under our powers and under our responsibilities, we have the responsibility to inform the public about data protection issues, right? So we need to say stuff and be like, we think this might be a danger to you. So at the Dutch DPA, what we sometimes do, we see that Meta is rolling out training based on people's Facebook posts, and we say like, hey, we want to warn you, make sure there's this deadline, you can object to the legitimate interest purpose that's going on there. That is part of our responsibility. And I think as a Dutch GPA, at least the reputation that we have in the Netherlands, and also with the commission that we've had for the past 8 years, we are quite tough on fundamental rights and human rights, or at least, right? That's the rhetoric that we have for ourselves. However, it's just, the practicality of it is just that if we always go in and they only see us when we are punishing people, it does something also to the voluntary information sharing, the prior consultations, the other types of stuff that people would come to us for. So it as much as it's like, again, it's a difficult balance to be in, but it's one that we have to be aware of, at least, that if we go too much into one particular rhetoric, we are undermining our own capacity to do the enforcement down the line.
Okay.
But it's just that when it comes to civil society in Europe, it's not as if we didn't sign a letter with more than almost 500 other civil society and trade unions against the regulation, which has been completely ignored. And actually, something that I find it interesting is that this articulation of the activist, radical activists that has been shaping up across many circles in industry and even in institutions, whereby you're an activist and so you don't know what you're speaking about. And I'm like, I'm a lawyer, I'm an academic, I study my subjects, and it's not because I'm against some of the proposals, because I want fundamental rights to be respected, that you shouldn't be listening to me, but you listen to companies. For me, I really struggle. I don't know what we should do. I think some of what we do is trying to create those bridges between civil society organizations. 2 days ago, we were at an event about LGBTQ IA plus rights in the digital age, and we're speaking about the omnibus, and they said, we didn't know so much about that. And I think those bridges, because all of it is very much intersectional when it comes to digital rights, but even well beyond, that we can do. We can do campaigning, right? Because what we know is that people do not want, as I said, do not want to be tracked. They do not want the rights to be undermined. They want big tech to be held accountable, but also any company in Europe that doesn't respect their rights. They don't trust the internet. Many of them, they have to be in the internet because we enjoy some parts of the internet, but also not with full trust, right? There's also always this, what's going to happen to me? Am I going to be scammed? Am I going to see thousands of ads? But I have to say there's something good in the omnibus. Not just something that is actually simplification, but something good that civil society has been calling on and demanding for years, which is privacy signals, automated signals, this idea that either on your browser or ideally in your operating systems, you can select whether you want to be subject to a certain processing operation from a certain controller or categories of controller. And this is machine readable, and this is automated. And once you said no or yes, I think it's really important to understand that you can also consent to this. They're going to remember your choices, right? And any company should be bound by this obligation, right? This is Article 8080p of the GDPR in the Omnibus. For me, it also should contain a part of e-privacy. We can speak to that because you can say no or to tracking, but there's other processing operations that are as per GDPR. And this is wonderful, right? Who likes this idea of maybe being able to send a signal to the browser or to your operating system and that they remember your choices when it comes to GDPR and e-privacy, when it comes to tracking, and then you don't see cookie banners?
Do you like the question? Whether we like it?
Yeah, you like it. It's whether we like it, right? You want it, right?
It's 1% of the problem.
No, of course, no. I'm never going to say, but I think this is why I said there's one good thing in the omnibus and something that we've been calling for. Actually, I don't think it's 1% of the problem. Of course, ideally, it should cover all kinds of tracking. This is why I'm so annoying with tracking, because we keep looking at the results of the processing of data, but the moment that somebody has access to your device and can start, accessing your data, then for me that's the problem, right? And we don't understand how they're using all of these data points, of course, for me. But just having this signal that at first can be about consent or refusal or withdrawal of objection, but later on, for example, because I'm also working on consumer law and something that is called the Digital Fairness Act, it can also indicate other choices from people, right? For example, I don't want to see addictive design. I don't want recommender systems, right? Because now we know that as per DSA, recommender systems should respect certain obligations. They don't. The next day, we're back to the old recommender system that you might like, but that we have. At EDRI, we have lots of enforcement when it comes to, thanks to Bits of Freedom and other organizations, when it comes to recommender systems. But that's the thing. I think because you said, how can we be proactive, right? And I think signals can be one part of it, right? Giving people control. Every time I say that, I believe I'm Donald Trump, but I think there's one good way for giving people control and autonomy in order for the rights to be respected, and in order to send, a signal, which is a message to all controllers, whereby I'm the one that has the decision. There's lots of discussion, technical discussions about how these signals could work, how they should be designed, and all of it. But this is, we already have a question. This could be good if it's if it legally.
I think it's like a very specific point that I don't want to get into because I do want to wrap up and open up the floor. But Maria,
So the role for academics. I have actually two ideas. Kind of. First is I think that with academia we already had this discussion about collectivism and so on, and I think in general, in our field specifically, this assumption that there is something like objective academics, especially in law, is just so false. And we are all coming with certain background, with certain biases and prejudices. Myself as well, I think you heard more or less where I'm coming from. But then we have obviously academics that are more coming from this, let's say, industry style, but they usually tend to present as more objective. Because so I think this is something that we need to completely get rid of. Like, it's clear that we as academics are coming from certain positions and are defending certain perspectives, particularly when it comes to law, which is all about interpretation. And this brings me to the second point, which is teaching and education. So I'm actually teaching in the advanced master's program, which means I'm teaching practitioners mostly, and they're mostly coming from private sector. So obviously we often have disagreements, and they know where I'm coming from. I know where they come from, and the core message that you always get from the legal education is that, well, it depends, and you can argue. And I think this is for the academics to actually enhance this more critical thinking and asking questions rather than just taking it as it stands. Oh, we need innovation. Okay, cool. So let's dismantle it because, of course, regulation will hamper it. So I think for the academics, it's important just to, educate and also approach our jobs as also it's something that where we come with the whole package. There is no such a thing that doctrinal objective stands on law. It's always coming from somewhere, and I kind of miss it. I think it's already kind of present on many parts, especially data protection, but it's not always there. So I think this plus teaching critical thinking and not just, what GDPR says and recite it. That's kind of...
I think that's a very nice point. I'm still going to take the moderator's privileges to sum it up a little bit. And I do want to zoom out a little bit because I think we're in this time where we're seeing a process that is fascisation. And we're seeing at the European level that there has never been a cordon sanitaire. We've never talked about whether there should be distancing between the parties from the far right. And we're in this moment where we're working up on a majority for far right parties on the European level, also in many European countries. And the European Commission and other parts of the legislature, the institution, are spending this time not preparing for that, but dismantling the rights that people could use to fight these things, dismantling institutions that are there to protect individuals. And I'm wondering whether that's time well spent. And I'm very much now looking forward to your questions and hot takes maybe as well. Thank you. We're just going to collect questions. There's one in the back there. Yeah, we'll just start off with that one. And then there's one in the front and one further back.
Hi, I'm Suza Varsa from Open Future. Thanks a lot for a really great panel. I want to zoom in on something that you pointed out, and I'm curious about, maybe you can elaborate a little bit, because this is something that worries me a lot, which is the lack of evidence for these claims. I'm a footnote nerd, so I go through footnotes and Draghi and I look where the hell do these claims come from, and it really pisses me off that it then stirs the whole policy agenda if it's like a slide deck from a consultancy, right, prepared for investors. So maybe if you know of more or like examples of this sort of stuff that comes in your practice. I know it very well from the whole EU AI industrial policy space, but I'd be curious to hear more on that.
Thank you. Okay, then we had another, maybe just for, I see you, Renee, you're next, and then Laura, I think, had a question right there. And then she'll come back around to you, Renee.
Thank you. Really nice panel. I really loved the discussion. I was wondering if part of the problem is not also that the GDPR has these beautiful principles that are just very, very difficult to translate. And then I think Mina said it, maybe we need more specific things. Maybe we need a list of prohibited practices. But how do we balance this? How do we keep our principles, which I think have served us reasonably, like I still like them. I think they are in many ways very useful, but how can we make this step to make them more concrete so that it's more clear how to actually apply them?
Okay, thank you. And then Renee, and then there's another question here in the front.
Thank you. René Mailleux, Open University, Netherlands. So I'm wondering, I think the core idea behind the Draghi report and this omnibus package is this competitiveness questions. And I think that for at least some in the political sphere, this is a genuine concern. It's not all just right-wing fantasies. I mean, there is this competitive question, and in some sense it's real. Or I think so. And I was wondering, I don't know, I was positively surprised for the fact that the council seemed to be pretty negative about this proposal. For me, it was not very clear on which grounds, but the results seemed to be kind of okay. But I was wondering, from your perspectives, maybe not for DPA, if your sense is that this is not your discussion to have, but how to engage maybe also with the different parliamentary groups on this in earnest, not to just say, okay, this is bad, because that we have all said that this is bad for fundamental rights, but actually to look into, okay, but what is it that you really want? Why would you vote in favor of this? I mean, I've written myself saying that I think if all of this would be accepted, or at least the part that I looked at, I think it's against competitiveness, so the situation they want to solve only gets worse. But is there a role for us to really discuss the actual underlying problem that we're supposedly trying to address? That's my main question to the panel.
Okay, then there's a question there, and then we'll take that as a last question, and so we have time to go through them a little bit as well.
I am going to Peter Itkostic from the Open Mind Foundation, developing open source software for privacy enhancing technology. I'm going to play the devil's advocate, but there's been 4 court cases from the European Court of Justice, including latest one from SRB, and none of you have mentioned it, surprisingly, and that's directly related to the change of definition of personal data. So does that count like for apples? Is the Court of Justice count for Apple? Is that your conclusions as academics?
Okay.
Sorry, can you
and
clarify?
then there was one last question that we'll take there, and then we'll see if we can do another round.
I'm going to be brave because you said you were open to hot takes as well.
Yes, absolutely.
I'm an ex-law academic and I work for TikTok now. And I see a lot of, again, with the caveat that it's a hot take, a lot of hatred against platforms like the one that I work for. And I wonder that there is this big gap between the policymakers and these businesses that the policies are trying to regulate. And how can we actually bridge that gap, Because I'm interested in both. I'm a human rights lawyer who is working in tech policy at the moment. So I'll be very interested to know, how do you think that, because businesses are the big elephant in the room. You cannot just work around them. You have to be working with them. That's what I think. Because they are the ones that you are trying to regulate with all these policies. But how do you make sure that you can take them on board? Because sometimes even I feel that some processes are just bad processes and they're very burdensome. But there are some processes that, even though it's very bureaucratic and feel like, oh, it's just red tape, you have to actually abide by them because there are bigger, fundamental rights at stake, and you cannot just violate them, right? So there has to be a balance to be made. And yeah, I just wonder how do we bridge that gap? Thank you.
Okay, thank you. We're going to start with it. Basically, we're going to give the floor to you in a second. I do want to, we'll see if we can do another round, and there'll be a break right after. I just wanted to, first off, start with 2 things. We're not doing a deep dive at this panel. You know that conferences don't really work with a deep dive. So if you're really interested in, though, I did publish a deep dive just recently that you can find on the European Law blog and just get very much into the depth of it, because I do think that is also important, aside from the very top-level discussions that we're having here. There is the deep dives, and Edri has been publishing things too. So if you want to know the positions, they're available online. You can just check them. Also, just something, because I do think that words matter. And I think, speaking of hatred, when we've seen this panel here, that's not maybe super behind big businesses, but I think words matter. So I think that none of us have engaged in hatred against platforms. I do think we see a lot of hatred on these platforms, and I think we have an issue with the platforms regulating that and getting on top of those issues. But I don't see any hatred, directed against businesses. And do correct me if I'm wrong here, but I have a sense that this word might be a number too large. But now I do want to give it up to the panelists. Maria.
So maybe continuing on this last question, indeed, I feel like actually the big tech companies have, at least the EU institutions during the legislative process are actually working a lot with them. So I don't think there is a big issue with lack of access to this discussion. Because we are just here discussing that we are now not addressing it, or we are more coming from critical perspective. This is just a panel at the conference. Obviously, the real negotiations are happening in the European Commission during the trilogues and so on. And who has access there? It's certainly not me going there. So that's another discussion to have. About actually mentioning the score, this is kind of why we didn't bring it up, because we decided not to talk specifically about the provision. However, I think Laura also mentioned this question about the balancing. And this is indeed the role of the Court of Justice, and its effect on how the GDPR is perceived and enforced is really unprecedented, because we really see that's another kind of paper to be written, I guess, about how the Court of Justice really, I won't say captured, it's maybe a strong word, but indeed influence a lot, including the DPA's judgments now, like how far can the DPA go in imposing the corrective measure and so on. This is really detailed, how far the Court of Justice is going in interpreting the GDPR, and for the sake of harmonizing, but so I think this is part of what courts can do further, but there's also clear that this is for the Court of Justice that we owe these very broad notions, the very broad notion of who is the controller, what is the processing, and so on. So this is also the space for the court and, well, again, the instruments that we already have, the courts and the DPAs on how to interpret the law. So, sorry, it's a very general answer, but another discussion we can have specifically on the concept of personal data.
Mm-hmm. I want to speak about the evidence, because I think that's really a huge problem. I won't stop saying that, because every time we challenge the Commission, and I'm fortunate enough to be able to speak with decision makers and also with the Commission, it's like we have extensive research, we have extensive consultations, and sometimes it's like, you've been part of this consultation, it hasn't. But there's none of it. And I had even from the Commission in one webinar, it's like, I know that you like to see the evidence, it's also, but I cannot show it to you, but it's there. And it's like, okay, but that doesn't mean anything, right? That we need to see the evidence. We're really speaking about things that are super important and that have a huge impact on, not potential, but that have a huge impact on fundamental rights. But now it seems to be working. That's my huge concern. Now it seems to be working. It's like somebody says, this doesn't have an impact on fundamental rights, and this is what the Commission keeps saying. It's like, okay, can you, even not with evidence, but can you explain that to me? And they just keep repeating SRB case. And I'm like, okay, but this isn't enough. They're choosing a very specific interpretation of the SRB case, and you're not looking at the whole of the ruling. Even that's hugely concerning. So I don't have an answer, but I think I think if I had the time, but I think this is also another problem that relates to the facilitation that Felix was mentioning. As civil society, I don't have the time to spend sending FOIAs every day, every hour. That should be my work now, trying to find the evidence, but I have to fight against that. I have to fight against attacks that demonize civil society. I have to look for ways in order to speak with decision makers who spend their whole day speaking with companies. And I'm really sorry, I hear you, but I don't think there's any problem with the gap between companies and decision makers at the time. I swear, every time I go to the parliament, it's like, I've met with 75 companies, and you can see the transparency register. This is the only transparency that we can access for now, because the commission is not really hot with transparency. And actually, I'm going to give it to you. I think that there's this hatred towards platforms that you mentioned. I think TikTok is a low-hanging fruit for a very specific reason that I don't really like. This is why I keep saying, okay, I'm happy that the commission has opened, preliminary findings, DSA. I'm happy with that, but addictive design is not just TikTok. Addictive design is all throughout the internet, not just platforms, all throughout digital services, right? And this is why this level playing field goes both ways, right? I'm not saying that TikTok shouldn't be investigated, but I think all of it should be investigated. But then we're going back to resources. And let me end with the competitiveness part. Of course, I don't think nobody has denied whether we have in the EU a competitiveness problem. Is it due to GDPR? It isn't. Is it due to any of the other laws? We all agree it isn't, right? I know Bradford has written extensively about that, right? It's about the single market. It's about the choices that we made when it comes to research, when it comes to creating, when it comes to advocating for more open source. Thanks so much for mentioning open source. I think the problems have been identified for years. Is that the Commission finds it much more easier to have this red herring. It's like, oh, this red tape is horrible. And something I'm really happy that you mentioned. Because I think it's really important. Friction is important, because every time there's friction when it comes to a regulator, when it comes to a company, that indicates that there might be a danger to abuse human rights. And this is, we don't want to get rid of that. Every time they say we don't want friction, it's like, I like friction, I like friction in many regards. But when it comes to applying the regulation, we need the friction, right? And red tape is another thing. I think red tape can be addressed with templates, and this is something that the EDPB has already addressed, and I'm happy to discuss. But also, when it comes to different political parties, some political parties are going to go about with their line. They don't care about fundamental rights, but this is why we keep mentioning other aspects that are important about the Digital Omnibus. It's not bringing legal certainty to companies. It's bringing a huge cybersecurity risk. All of this data brokers, we've seen that in the United States. ICE going to data brokers and to ad tech companies and forcing them to, do we want that to happen? We know that the number of cyber breaches is growing every month in the European Union. Do you want your data to be subject to that? I don't think you want. It's going to happen even more if this Digital Omnibus goes about. There's so many things that other political parties that are not the most progressive parties should be looking at when it comes to the omnibus if they don't care about fundamental rights, which they should. So yeah, I think we need to tailor our language with some of them. We have a cordon sanitaire, so there's so much I can speak with the far right. But I think even the far right should be concerned about some of the aspects of the digital omnibus.
All right. Okay. So we had 5 questions. The first one on lack of evidence, I think you've talked about now. The second one from Laura about the balancing concreteness versus principle-based. I think there is no perfect answer to this, right? That's the different traditions that we've tried with the lawmaking. I do agree that the approach at the moment of a risk-based approach, in general, I agree with those, but we see that the real, at least from the DPA point of view, the real burden for many of the organizations is the interpretive work that they have to do on that law, right? So anything that we can do on specific situations where you can say, well, this is not so much risk-based anymore, but just you can't do this, or we strongly advise against that, I think would actually help them. So I think what we've seen with DSA, AI Act, other ones where there is that kind of tiered approach, I think might be a middle ground. But we'll have to see ultimately how well those laws are going to work, which I'm not sure about. Then the question on how to engage with different groups actually constructively, I think for me personally, it comes down to actually having the evidence to back up those discussions, because otherwise we'll just end up in a rhetorics situation, right? And I have my own values, obviously, and I have my own experiences and what we see at the DPA, but I also want to be open to actual substantive arguments from others, as long as they're based in reality in some kind of way. The question about the CGA EU definition, personal data rulings, I wasn't quite sure if I understood it. I think what you're trying to say is there have been these rulings, so clearly there is ambiguity that needs to be figured out, so why would you just ignore the fact that maybe there's a problem that needs to be solved? I'm not sure if I take these cases going to the court as evidence that there is ambiguity. I think it's just because that's the very first step that you have to take as an organization, namely, does the GDPR apply, yes or no? Is there personal data, yes or no? It's obviously going to be the most contested one. So it's more likely to get to the court level. However, if we want to look at those things, I think we shouldn't just look at the SRB. outcome, but all of them that we've had. And then the last one on bridging the gap between platforms and lawmakers, I think I agree with what Maria said, which is I think actually those organizations are the ones that have the most access to the Commission compared to many of the smaller organizations or NGOs. So I'm not sure if I see that as the biggest problem.
All right, thank you. Now we would have time for one last question. Burning. And then everybody gets a sentence, and then I'll cut you off. Because we all need our coffee.
Unfortunately, it's not that burning, but I'd really like to know your opinion. I work at a economy university and on the intersection of privacy and cognitive science and also digital economy.
I should have said that. You also only get a question.
Yeah, it's a question actually.
Intro.
When I read that this is supposed to improve our competitiveness by getting rid of our current definition of personal data and so on, where this logic comes from your perspective, I have not seen that much of evidence that, okay, this is it. This is, I think, a very important matter to discuss because, why we are thinking that this is, would help us from economic perspective, honestly, not just privacy.
Yeah, thank you. It's interesting to me that somebody who works on economy also doesn't see the evidence, but maybe you...
I think it's a tension that is always present whenever you try and regulate anything, when the biggest, most important kind of like powers in society are about, economics and capitalism versus protection of fundamental rights. So there's always going to be, we've seen it in the history of the GDPR also with earlier versions of that, data protection directive, OECD principles, whatever, there is always been a bit of a rhetoric around we need to balance the fundamental right protection with competitive advantage, data flows, whatever. So I think it's always been there. And I think
my mistake, I let you have 2 sentences. Okay.
Yeah.
No, I'm just going to end when you ask me what did I like, something that was put on the table when the GDPR was being negotiated and all these conversations about innovation and fundamental rights were had is that we had the hope, there was an option to ban surveillance advertising, and maybe now is the time to recover that hope. We need to ban surveillance advertising, and I think after that, many of these problems, I'm not promising anything, but some of these problems, if not all, many of these problems will be solved, right? So maybe we have to push for that, ban surveillance advertising. You spoke about
okay, it's too many sentences, but I like the point. Okay, Maria.
No, regarding this question, so, well, the logic I think is quite straightforward. If you apply in the most broad way this exemption, you can just exempt yourself from the GDPR by saying this is not personal data, the one you process. And then the logic is, but I don't think I see evidence for it. If GDPR doesn't apply, then suddenly I have a freedom and capacity of my organization instead of compliance, focusing on these innovations. However, as I think, most of the innovation has actually changed the world, were coming from state-funded projects in these environments that were not economically driven, and then later they were privatized. So I was just thinking, where is it coming from? What does it need to actually achieve? Here, I don't see straight. I think it's quite a gamble to assume that we will immediately have groundbreaking discoveries and competitive projects. So.
Too bad, right? Yeah. Okay. Well, thank you very much for coming. Thank you to our speakers, and see you in the coffee break.